Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. The California Appellate Law Podcast is a resource for trial and appellate attorneys. Both Jeff and I are appellate specialists, but we split our time about evenly between trial and appellate courts. And in each episode of the podcast, we try to give our audience of trial and appellate attorneys some news and insights they can use in their practice. If you find this episode a resource, a good resource, please recommend it to your colleagues.
And if you don't like it, send it on to your opposing counsel. And a quick thank you to our podcast sponsor, CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse their service. And listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
All right, Jeff. And today we are pleased to welcome John Dodd to the show. John has been a certified appellate specialist since 1996. I'll have to ask him when they started issuing those certificates, and has handled over 1,000 appellate matters. Let me stop and back up a minute and read that more slowly. John has handled over 1,000 appellate matters, and John has been practicing for over 30 years. After graduating from law school, John worked as a staff attorney with the 5th District Court of Appeal, and he practiced with private law firms before founding his own firm. He's admitted to practice in California and the Supreme Court of the United States and the United States Courts of Appeals for the 7th and 9th Circuits. Originally, John's law practice combined civil litigation and appellate practice, but later he transitioned to devoting his practice full-time to appellate matters, and he's done that for over 20 years. And a couple other nuggets from John's very long CV. John has served as a member of the California Advisory Commission to the United States Commission on Civil Rights from 2007 to 2013. In 2004, John served as the chairman of the Committee of Bar Examiners for the State Bar of California after completing 3 years as a committee member. And from 1998 to 2001, he served on the Commission on Judicial Nominees Evaluation, colloquially known as the Jenny Commission for the State Bar of California. So without further ado, welcome John Dodd to the podcast. Thanks for being here.
Thanks, Tim and Jeff. Glad to be here.
All right. Well, let's continue kind of doing a vitals, bio lightning round here, and talk a little bit more about your practice area. Now, you do exclusively appellate work for the past 20 years. What kinds of appeals? All types of appeals, or do you focus on some?
All types of appeals. We've stopped. We don't do criminal appeals anymore unless it's from somebody that I've already done a case with in the past, a trial attorney. I do have one capital case that's pending, but it's about pretty evenly split between appointed dependency cases and just regular retained civil cases. Today I'm working on a probate case. It can be probate, real estate, family law. Basically, as far as I'm concerned, an appeal is an appeal. Unless you're into some arcane area like CEQA or something, you have to read everything every time to do it right anyway. So I don't think it really matters what kind of case it is.
Oh, interesting. I was going to ask you about that. So you just said an appeal is an appeal. So when someone comes to you with a family law appeal or a personal injury appeal or a probate appeal, do you just see it as an appeal? Obviously, there are differences. But tell us how you see those differences after 30 years and over 1,000 appeals.
It's actually over 2,000 appeals. I have to update my bio, but
no, we'll really never catch up.
Well, the basic fundamentals, you have to figure out the standard of review. That's always a key thing. You have to be able to organize and describe what happened in your statement of case and facts. That applies to any kind of case. And there are so many issues, unless you're dealing with, let's say, family law, which generally have, I don't know what the number is, maybe 10 primary issues, move-aways, business evaluations, things like that. But within a family law case, you can have a variety of evidentiary questions that aren't really family law questions, but they're evidence questions. And so those cut across any kind of appeal.
Right. So you've got your specialized types of questions in any particular area, but all civil appeals will involve standards of review, evidentiary, evidence type questions, or just a lot of bread and butter issues that any appellate attorney is going to need to learn how to deal with.
Correct.
Okay. One nuance that I've noticed in juvenile cases. Now, when I review recent opinions to find interesting things to write about and talk about, I usually zoom right past those juvenile dependency cases. They're too much for me. But I do notice, because I have a Westlaw alert set for CCP 909 findings. That's where the Court of Appeal can make findings on its own in the first instance, and the Court of Appeal always says that we very rarely exercise this discretion, and I've actually only ever seen it done in these juvenile dependency cases.
Right.
So is that a consideration that you have to be aware of, be top of mind when you do these juvenile dependency cases? Should I ask the Court of Appeal to make a finding?
And generally, the courts will only do that in order to affirm the case. Oops. Something popped up on my screen here. Sorry about that.
Okay. We
probably continued to see me, but I didn't see you.
Yeah.
So they only do that in order to affirm the case, but in very rare instances will they take additional evidence to reverse. And they're generally very loath to do that, but it's very active in the dependency cases these days. There's this hot issue of the Indian Child Welfare Act, and it's basically not an Indian Child Welfare Act question, it's a standard review question or a standard prejudice questions. My office, my wife and myself were appointed on this case. We just filed an opening brief on the merits last week. And the courts of appeal around the state had no less than 7 different analyses on the proper standard of evaluating prejudice, whether that's reversa per se or never, when hell freezes over, type standard of evaluating prejudice. So in these cases where the county maybe didn't properly notice the Indian tribes, then the county will run around and do it after you file your brief, and then file a 909 motion and say, well, we fixed it now. And a lot of times the court says, too bad, you didn't fix it earlier. And sometimes they take it. So the 909 motions, and that's another hot topic, actually, in these dependency cases, because in a dependency case, you're marching along, you have initial hearing and then hearings all the way along for about 2 years. And so stuff can happen. Folks can die, folks can get their kids back, all sorts of things can happen. So taking additional evidence on appeal is something which is often considered in dependency cases.
Yeah, and you mentioned, and I've seen this law on that as well, that those 909 motions asking the Court of Appeal to take evidence and make a finding in the first instance without having to wait for the time and expense of sending it back to the trial court to do it. The Court of Appeal rarely does it, and usually will, if it's going to do it, it will tend to do it more often if it's going to result in an affirmance of the order. And I don't recall that being part of the 909 statute, that the court shall do this rarely and only in favor of affirming. That seems like a judicial gloss on the rule, that we're gonna do it more in favor of affirming. I remember reading a Justice Reilersdam column a couple of months ago, responding to the objection that, well, don't the courts have their thumb on the favor of the respondent? Isn't it in the affirming business? And his response is, well, the court isn't in the affirming business. It is in the affirming business, but only because the statutes and rules are written that way. But Section 909 isn't written that way. Yet there's a judicial gloss on it that suggests that the courts has put itself in the affirming business.
Right, that's true. It's a ZFS case is the case that they don't take additional evidence for to work on reversals, just on affirming. So.
Yeah.
Interesting. Hey, John, on the subject of dependency work, I've never done it. I've done appointed work in the criminal context. Can you talk a little bit about dependency cases and why you do them, and why you accept appointed work when you could probably command a high hourly rate and have your plate full of civil litigation for the rest of your career? Why do you bother with dependency work?
Well, a couple of reasons. One, when I left the court 30 years ago and came back, I was in Fresno, came back down here to open my practice. I was with And then that's why I applied to the panel. You got to have some work to do. And so I handled those type of cases. So I checked that box, and I've been doing them, and I've been doing them ever since. And so it's sort of an unending flow of work, which is probably a sad commentary on our society. But like we were speaking before we started, during COVID, when they shut down the courts, there weren't a lot of civil appeals because there weren't a lot of judgments.
Right.
But there continue to be dependency cases. Plus, there is some satisfaction in you have to put your client in the box that the overweening hand of government is just interfering with their family unnecessarily, and sometimes you get those cases. And so I remember talk about, you were wondering about war stories. So one of my war stories, we had a case, and the child was mentally challenged, and the parents were a little slow themselves, and it was basically a dirty house case. And
a dirty house case. What do you mean by that? Like literally?
Well, I guess in the jargon, a dirty house case is the parents do not keep the house fit enough to live in.
Yeah.
It's full of trash. There's debris. The kitchen's filthy. Everything's filthy, and it can be disease ridden and a hazard for the kid. So these folks cleaned up their house, but the county wouldn't give them their kid back. And then so that was the appeal, and eventually we won. But they had the social worker would go out there and describe conditions, as I think it was a Justice Sills opinion, that would be common on any farm in this country. There was an outboard motor sitting there. There was a wading pool with water in it. Okay. And this sort of thing.
Yeah.
And then so
there was a Simpsons episode with the social worker coming to the house and pointed out that the toilet paper roll was installed in the improper underhand fashion.
That's right. And so we got that reversed, and to make sure we got it reversed, my son, who's an attorney now, in his high school, we got his high school key club, and they got out there, and we cleaned up these people's house. We cleaned it all. We got donations from IKEA and Home Depot and all this stuff to make sure these people weren't going to take these people's kid again.
Yeah.
And so and this is one of the ones that just kind of limped into interview land. And so he was on the radio, and we were on John and Ken, and he says, one time the social worker came out and said, there are too many wasps. What am I supposed to do about wasps? So every once in a while you get those kind of cases that you are preserving families that need a little leg up, and then the rest of the ones, you want to make sure it's just like the regular public defender. We have something called due process. Right. And I've won multiple cases where they didn't give the proper notice, or they just kind of made something up as they went along, and you got to have due process. And so
how long have you been doing these cases, John?
Pardon me?
How long have you been doing these juvenile dependency cases?
Oh, the whole 30. I've been practicing 35, 36 years, and probably the whole 32, 33 that I came back after the court, I've been doing those.
Yeah. And so you find it rewarding for those reasons, or does it get depressing sometimes?
Well, it's not really depressing. Sometimes it's just kind of the same thing over and over, but it's not the same thing over and over to those people.
Sure.
As far as the impact on their life, it's a new thing. And so, and then in the law was changing quite a bit. And anytime when you get the law changing quite a bit, well-intentioned judges make mistakes. So you get a bunch of reversals. And they're just doing the best they can with, not enough resources and too many customers.
Yeah.
And so, when a judge gets reversed, I think a lot of them don't take it personally, especially when you get in an area of, in the laws and flex, like this Indian child welfare stuff.
At what stage of the proceedings are you coming in? Has the appeal already been filed, or do you consult in whether to take the appeal?
Right. The appointment system works just as the criminal system worked that Jeff worked in. The trial attorney will file a notice of appeal, and then it goes off to one of the appointing agencies. for the different districts, and then they just kind of parcel them out. They just call you, or they just send you an email these days saying, you want a case, you want a case, you want a case. So.
Is there a similar procedure as in criminal where if the appellate attorney finds no substantial issues, if you find no substantial issue in one of these juvenile dependency cases, can you beg off the case?
Well, you can't beg it off. You got to file a brief, but it's a Phoenix brief as opposed to a Wendy brief.
Right.
And the procedure differs by district. Some of the districts, you just file a letter and they immediately dismiss the thing. And then other districts give the client 30 days to file something.
Got it. So, so in all your work and over 2,000 appeals, do you like being the appellant, the underdog, or do you like winning, being the respondent?
I was thinking about that. I suppose I'd rather be the respondent, but when you're the respondent, you're not coming up with cutting edge new legal theories. You're not changing the law. The whole purpose of being the respondent is to say nothing to see here, keep moving, nothing to see here. And so to that extent, you like being the appellant because, sometimes when you win, it can really change. It can be a game changer.
I wonder if when you're the respondent, if you're like me and you like finding those appellants who are not represented by an appellate specialist or a listener to the California Appellate Law podcast, and you pull out your rules of court and all of your respondents trap, you forgot to cite all the evidence in a substantial evidence issue, or if you cited the wrong standard of review, or you didn't pull all your key arguments under their own separate headings.
Right.
Whammy.
That's right. Unless the courts look to affirm. They really do.
Yeah. What was it like being a research attorney at the 5th District Court of Appeal?
Oh, it was a very good experience. I guess every court's different, and I was only there. I wasn't at the others, but you get to hang out with people that know a lot more than you do about, and every justice is different. Some justice were micromanage the whole thing, and other justice, looks good to me, so when you give them their memo, and some send it back, do it again, I don't like that. So, but it's, you get exposed to a wide variety of topics. We did, it wasn't a dedicated staff, so I did criminal cases and these dependency cases and the termination of parental rights cases, which is sort of not really dependency, but it's the private, like contested adoption cases, and that ended up being sort of my specialty in the civil world, as well as just regular civil cases. But we did a little bit of everything.
Did you take any tips, like brief writing tips, with you from your time on the Court of Appeal?
Yeah, I would say it's just all the regular things you usually hear. Be short. If you can, you go. Especially now, they're really overworked, so they really stick to these 14,000 word limits. It's amazing how we used to be able to have a 19,000, say, well, I got a 3,000 page record and there's 10 issues and and they'd say, okay. Now they just say no. So you have to go through and shorten every single sentence. And you have to, and to do that, after you've done that, then you sort of ingrain that habit, use active verbs and use 2 words instead of 3 throughout the whole thing, and that makes your brief easier to read and clips right along. And as you mentioned sort of before, it's sort of a rule, have all C subheadings. Make it easy on the court, and that's the thing. The court, they all say how they're overworked, as if we're not, but make it easy on them to decide in your favor, no matter which side you're on. I always think that you should be able to read an introduction and say, well, that person might win. And then you read the table of contents and say, oh, yeah, that person might win. And then you read the brief and say, that person's going to win. But so it's, you make it easy on them, and don't hide the ball. Don't be cryptic. You don't want to be boring. It doesn't have to be Dragnet style, but it doesn't have to be too flowery either. I'm sure they appreciate a good turn of phrase here and there, but I think too much of that distracts from your legal argument. Just so that's it. Make it as straightforward as you can and make it easy for the court.
Yeah. Now, when you started your practice, you were doing both litigation and appeals. And then after some years, you progress to doing exclusively appeals. Can you tell us about that progression?
Yeah, so we, it's kind of hard. You guys do a little both, so you probably know. But when you got to go do a deposition, when you get ex parted into something, it's kind of hard to, if you have, if a smaller appeal is one thing, but if you've got a 4,000 page record that you've got to get through and a due date, and all of a sudden somebody dumps a motion on your desk to answer, if you're not the person in charge, or if you are the person in charge, the other side sends you an ex parte something that you've got to answer, that just disrupts your whole flow. And so it just became increasingly difficult to do both. And it's so that's why, I don't take anything, I don't gainsay trial counsel. I used to be a trial attorney, but I probably haven't been in a trial court for 20 years. I couldn't, lay a foundation for an expert if you paid me, but I can read the record and figure out how they didn't do it.
Yeah.
But, I have to, but so that's the thing that, everybody, I tell people I don't do plumbing either.
Right.
They're really different skill sets, I think.
Right. What are some tips that maybe that you might have for trial attorneys, and maybe they're not at the appeal stage yet. Maybe they are, they're pre-trial. Do you have any tips for them? I always get frustrated when I've got a client who comes to me with an appeal, and I say, well, you would have had a few good issues here, but the proper groundwork wasn't laid for them at the trial, and I would prefer to be able to help them do the right thing rather than tell them what they should have done. I wonder if you have ways of conveying that to trial attorneys.
Probably the most important is no secret is to make sure you have a record. A lot of people, I asked, well, there was a reporter, and they say they don't know. Why don't you know?
They don't even know if there's a reporter?
Right, or if there's an electronic monitor these days.
Yeah.
I don't know. Well, it's on the minute order, and I guess LA, you can order them online. But if you have some kind of a dispositive motion, or even something that might go south, have a reporter, because otherwise you've got to do a settled statement. You're not dead in the water, but you lost. That's why you're coming to me. So
Yeah.
you're going to write up what happened, and the other side is going to write up something totally different and say that's not what happened. They didn't say that. They didn't make that objection. And the judge, we're all assuming all trial judges are men and women of goodwill, but they want to protect their ruling. They're not going to say, oh yeah, I called this guy a dirty SOB in the middle of the hearing.
Right.
They're not going to do that. So, and along the same way, if you are in a court, like a lot of times in family law, they do all this stuff off the record. They go back in chambers or just do it off the record.
Right.
Well, when you're done, you just say, Your Honor, I'd like to place on the record, bit, 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 bit. And a lot of times the judge may get a little irked, but, that's too bad.
You got to get it on the record any way you can.
Get it on the record any way you can, and then, take your lumps. And I know it's easy to, for me to say that, because I'm not the one taking lumps and getting stared down by some judge that I'm going to have to appear for before next week. But you've got to do it, because if it's not there, it's not there.
Yeah. I've sometimes suggested to trial attorneys, if their client is not well heeled enough to hire a separate appellate attorney to serve as embedded appellate counsel at trial, at least have an appellate attorney, on consultation retainer, and call them up at the end of every day of trial and say, here's what happened. Here's the key evidence that we were able to get in. Here's what we weren't able to get in. And the appellate attorney maybe could advise, okay, tomorrow you need to, put something on the record. You need to do an offer of proof or whatever it is to help try to patch the holes.
Right. And not only do an offer of proof, do an offer of proof in writing. Bring in a piece of paper, because that's going to get stuck in the file. And fall on your sword, I'd like the court to reconsider. I know you said this and that and the other, but I really think, all he or she is going to do is yell at you. They're not going to sue you for malpractice. The judge isn't. So.
Right. Are there any common mistakes that you see trial attorneys make? Anything from poring over the record in over 2,000 appeals, that issues that I had mentioned that, gosh, this would have been a great issue, but there wasn't enough of a foundation laid for it. The attorney, this would have been great evidence that was excluded, but the attorney didn't try hard enough to put it into evidence. What kinds of trial attorneys do you see come up again and again?
Well, those are probably the main ones, but other than that is getting too emotional. I mean, if you've got to be able to emote and convince a judge or jury, but you've got to keep tethered to reality also, and to really not get blindsided by what's going on the other side of the table, because you think your client's been wronged horrendously and you're going to right this wrong, and isn't this horrible, and you can't see the other side. You've got to be able to see the other side and then make your record about it.
Yeah.
Hey, John, is there anything, maybe I should ask Tim this question, but I'll ask you first. Is there anything unique about the way you handle appeals that your opponents would say about you, or maybe appellate justice would say about how you or your firm approach or handle appeals?
Well, I was looking at that question on your list. I think that as far as from the client's standpoint, I'll tell them if they don't have a decent case. I know there are people out there, because people have gone from here and gone to them, and then they get this scathing opinion because I'll sign up for email notification on cases that people talk to me. And well, what I do is I review it. I do like an initial review at a reduced rate, and for half a day or a day, depending on if it's a motion or a short trial. It's going to take longer than that for a longer trial, to see if it looks like we have what we call an arguable legal issue. And then I'll tell them, I'll just say, excuse me, as I mentioned earlier, I'm fighting off this cold. You have an issue, but it's just not going to happen. There's no way. And in many cases, I just say, I won't even brief it. I won't do it. And
hey, let me ask you on a related point. So you're talking about viability or frivolousness. Are there any cases or arguments that you won't make, or cases you won't take, not because they're frivolous, but just because of the ick factor? You just don't want to handle them?
Well, no, because I don't do criminal appeals anymore. I've had 2 capital cases, and those have significant, serious things going on. But it depends. Most of the appointed cases, you technically get a choice, but you don't get much of a choice. And there's either a legal issue or there's not, and you don't meet the person, anyway. And as far as the private cases, if they have a legal issue, they have a legal issue, as far as I'm concerned. I mean, I suppose you could look at, let's consider restraining order cases. A lot of people think they give restraining orders away a little too easily. And with, it's good reason to err on the side of caution. But, maybe the person, is not the best person that you want to invite over for dinner Sunday night. But if in fact they've been wronged, I think they deserve an appeal.
Right. Interesting. Yeah. Hey, in criminal law on appointed work, often ineffective assistance of counsel is a thing. For dependency work, is ineffective assistance of counsel or commenting on the quality of the trial work, is that something you get into?
Well, they all think that, all the clients, but it's usually not. Trial counsel do sometimes make mistakes because dependency trial counsel are very overworked, a lot more overworked than criminal law trial counsel. But they're all generally panel people or agencies. These kind of like public defender's office and 1, 2, 3, 4 in LA. And then that's all they do all day, every day. So they're usually not ineffective to that level. But when a private person comes to me in family law or something, I just say I don't opine on that. My job is to look and see if there's a legal error that appears to be prejudicial, And if you tell me your attorney didn't do this and didn't do that and didn't do the other thing, then you need to go talk to a malpractice lawyer, because I don't get into that. And practically speaking, I don't know what discussions occurred between that client and that attorney. The client comes in and says ABC, and then, you go to the attorney and he or she will say, DEF. It just didn't happen that way. And then so I just don't get involved in that at all. And I explain that there is no in civil cases, there's no ineffective assistance.
Nope.
You may be able to, if it's soon enough, you may be able to do some kind of reconsideration motion or whatnot, or a new trial motion. If you could pin it on accident and surprise. I mean, there's arcane writs, coram vobis and nobis, but that has to be information that not only you didn't have, but you couldn't have at the time. So basically, again, I tell people I don't do plumbing and I don't do ineffective assistance of counsel cases.
That's interesting. With your years of work in this field, I know you don't comment on malpractice, but do you ever serve as an expert witness or standard of care for legal malpractice cases?
No, I almost had one a year or so ago, but they got someone else. It was a major law firm that had allegedly missed something in an appellate brief that they should have raised, and I was going to work on that, but I didn't. And it's just I'm happy doing what I'm doing. I don't need to branch out.
Well, let me ask you this then. Other than writing appellate briefs, what is your favorite part of your practice today? What do you enjoy doing the most when you come into the office?
Well, I suppose I was thinking about that. It's two main different prongs. One is coming up with cutting edge legal arguments that maybe you just come up with. And for the appointed cases, it's just something that you stumble on. You have no really luck of the draw. It's like, you may know that I did the Sanchez case in the Supreme Court, the hearsay exceptions, the case-specific hearsay. And
no, I didn't know that was you.
Yeah, that's my case.
That's your fault?
Yep.
You're okay.
And that's totally the luck of the draw.
Yeah.
And I have another one pending right now. Speaking of restraining orders, now that the Supreme Court's issued, U.S. Supreme Court issued Bruin, there's a very good argument that the firearm restriction in all these restraining orders is unconstitutional.
Really?
And I'm arguing that in one case right now. So, and you just, doing workers' comp defense all day, you just don't get those meaty arguments. The other case that the U.S. Supreme Court has right now is the constitutionality of the Indian Child Welfare Act, and they just argued it, I think, last month. Well, I developed all those arguments in '96 and in 2000 in Bridget R. and Santos Y. I mean, I read every single Indian case that the U.S. Supreme Court had ever written. I read the entire Felix Cohen handbook on Indian law. And I built these arguments about the 10th Amendment and racial discrimination and this and that and the other. And then so that sort of went by the wayside, but then somebody else came up with it. I think it was out of the Fifth Circuit. But that's pending in the U.S. Supreme Court right now. Of course, nobody called me, but but every once in a while you get the meat of it, and that just doesn't happen that often. Yeah. And I guess the other half is that I've got a dress shirt on right now, but it's not. I usually wear a polo shirt and shorts and no tie.
Right.
And it does give me some flexibility. Now I have a lot to do, so I have stuff to do all day, every day. But I'm active in some very specific organizations, and if I have to go travel and do something, that it may mean that I have to work more the week before and the week afterwards. But it gives me the flexibility to go do that, because you just, when there's an argument date or a due date or emergency writ or something, then you don't really have much flexibility. But other than that, you've got a little more flexibility.
Yeah. So it sounds like a moment ago when you were talking about you in some legal issues, important legal issues, you've been at the front lines, like you're the attorney on the Sanchez case concerning the what's the rule about the hearsay, non-case specific hearsay.
Right.
You did all the legwork on the Indian Child Welfare Act way back in 1996, and now it's being brought up in what do you say, 10th Amendment constitutional litigation concerning states' rights issues. And so is there a secret to that, or is it just being around and just rolling up your sleeves when you find the interesting meaty issues? And what, one of these days, like you said, luck of the draw, is what you attribute it to in Sanchez. You just wind up on the front lines of some of these issues.
It really is luck of the draw. I was thinking I have a related case on construction licensing and that kind of thing. I did the Jeff Tracy case, which I don't know if you do any construction law, but it's some of those things are private cases that are just luck of the draw too. You just have to kind of be open. Unfortunately, most things need to be preserved in the trial court. Again, not only your facts, but your legal arguments, because there's case law out there that says that a trial judge can't be held to have made a mistake if he was never asked, basically. So most issues need to be raised in the trial court, but not all. It just depends what the Court of Appeal wants to set its teeth into. And you never know if some question is some pet peeve of some justice from 20 years ago when they were a trial attorney. You just never know what's going to really pique their interest, because they have so many cases that are mundane. But if you can make your case something that piques their interest and can justify going, where no man has gone before, they'll do it if they want to. But if they don't want to, you're done.
Yeah. Well, is there a secret to that? You say it's important to find an issue that piques the justice's interest. So there's got to be some value in going to a lot of local bar events featuring these justices and following what kinds of issues they're interested in, what kind of arguments and cases they're interested in. Is that something that's been of value to you when you served as a research attorney at the 5th District? You must have gotten to know what kinds of cases piqued the interest of the various justices there.
Sure, back then, yeah. But I've been doing some other things. As you may recall, I was very active in the bar here. I was on the bar board and
right,
that sort of thing, and went to a lot of events and a lot of justices are very upfront about where they stand on certain issues. The late Justice Rylersdam for one, and late Justice Sills for another. I won't talk about any living justices, but if you can figure out their judicial philosophy and put yourself in that box, it sure doesn't hurt. Probably, I don't know whether it's 90% or 95% or 85% of the cases, they're going to come out one way. It's you have to see if your case is in that minuscule swing district of cases that you can change somebody's mind about something and take it in some other direction.
Yeah. Hey, John, you've been doing this long enough to remember what it was like to litigate and handle appeals before the anti-SLAPP law. And, a lot of people think anti-SLAPP law has clogged up our courts because of the instant right to immediate appeal. And other people think, well, but they get rid of frivolous cases fast. They clear up the docket that way. What is your take on California's anti-SLAPP law? Is it net plus?
I think so. I've only had a couple anti-SLAPP cases, and none recently, because I find that, I don't know whether you guys have those, but once you start doing them, people come to you. And so I haven't been doing them lately, but it seems to me it makes sense. But it's sort of its own cottage industry, as you are sort of alluding to. And so it seems to me that it's better to get rid of these cases. Litigation is so expensive these days that if you can weed something out earlier, you ought to do it.
I got to tell you, I do a lot of anti-SLAPP work at both levels, trial and appellate. And I would like to see the sanctions part have more teeth for when a frivolous anti-slap motion is filed, because when an anti-slap motion is frivolous and a case is the brakes are put on a case for 2 years, no discovery, etc., it could be devastating to a legitimate plaintiff with legitimate claims. So I'm a big fan of the anti-slap law. And I think 90% of the time anti-slap motions are righteous, but sometimes it's abused. Yeah. Interesting. Hey, we talked a little bit earlier about court reporters, and when you started practicing law, we had a court reporter in every courtroom: family law, probate, harassment, restraining orders, etc. And now, LA just announced they're not going to have court reporters for family law or for restraining order hearings, and you got to bring your own. And it seems like court reporters are not available because they're not available. It's not a matter of throwing money at them; they're just not available. Where do you see, with your years of experience, where do you see the court reporter shortage ending in terms of preparation of records and transcripts and how it impacts appeals?
Well, I haven't really thought of that. I think as they go more towards, if electronic monitoring seems to make sense to me, because then if you need a transcript, you can get the recording transcribed. And that would alleviate it. But for some reason, they're not even electronic monitoring a lot of these things. And I don't understand that. And I guess the courtrooms just don't have the technology. Like I said, I haven't been in a courtroom for a long time. So,
yeah, you had mentioned about the electronic recording system that I think is still active and available in some of the limited civil departments. And I wonder if you ever handle any appeals that deal with those. Electronically recorded records.
I've had, I probably get one every year or two, limited civil, and some of them have the electronic monitoring, and you can, I guess, I forget whether it's Orange County or LA or both, but you can have the audio just sent right to the appellate division, or you can have it transcribed. So I did have one last year that we did that. We just had it transcribed.
You have it transcribed, and does the transcription get sent up to the Court of Appeal as well?
Right.
Yeah. Okay. And did that work out fairly well, or were there a lot of garbled audio?
It sounded pretty fine.
Okay. Yeah, I'm doing some research for a piece on the court reporter shortage and looking at the legislative record for all of the the alleged deficiencies of the electronic recording system. And this was back in the 90s, so they had physical tapes, and someone would have to be there to change the tapes out every 45 minutes or whatever it was. And I think we've been able to surpass a lot of those problems. Here we are 30 years later, and we're doing everything via Zoom. And most new attorneys probably never even heard of a cassette tape.
And of course, the Court Reporters Union wouldn't be in favor of more electronic monitoring.
No, probably not. Although there's you'd think that there'd be less invective because there's simply a lack of human resources. Just not as many people becoming court reporters anymore. So it's not like a job security issue like it was 30 years ago.
Well, it is a pretty exacting task. I mean, I couldn't do that. So
yeah. You don't do plumbing. You don't do court reporting. Right. I'll make a note of that. Hey, John, I was wondering on the issue of oral argument, putting aside compensation issues, whether or not the projects compensate you for going to an argument or not, putting that issue aside, what is your general philosophy on going to argument, waiving argument, insisting on it, if you're the appellant or the respondent? What are your thoughts about the utility of oral argument?
Well, I think Justice Bedsworth once said that you should always ask for argument unless your client can't pay for it. And you don't want to do it for free or something like that. Usually it's a waste of time, but the problem is you don't know. You don't know if your case is in that 10% of cases that it's not a waste of time. And so in civil cases, I think always, I won't say always, because I'm sure out of 1,000 retained cases, I've not asked for argument a couple times. Sometimes as a respondent, if the appellant, let's say they do the appeal brief and you do the responding brief, and their case is just garbage and they don't even file a reply, I don't ask for argument.
Right.
As that gives them an opportunity to say something about your respondent's brief. Whereas if it had been the normal sequence of events, you get the reply brief, and then you decide as a respondent whether you think you better ask for argument or just skip it. So even in a retained, so I would say in that instance, in a retained case where the appellant is horrible and they don't file a reply, I don't ask for argument. But other than that, I do ask for argument, but I try and keep it short. You know, my time estimates are usually 7 minutes, 10 minutes, 12 minutes. You know,
I usually ask for 9 because in the
9.
second district they do the shortest arguments
right,
first.
because you can get in front of the 10 people.
Get in front of the 10 people.
The price is right. Yeah.
But you know, and it's just kind of hitting the high points, and that's how you can tell the guys that are the trial people doing their own appeals from the appeal people. You know, I walk in with a little red rope folder and some yellow pads, and they come in with a wheelie cart for 3 boxes. You know, what the heck are they going to do with that?
Yeah.
So
Yeah.
Well, what was
know,
it? I think Justice Ryler's there's someone on the 4/3 here used to say when they got a 15-minute oral argument estimate, 15 minutes, counsel, were your briefs that bad?
Yeah.
You know, you just want to hit the high points, and because sometimes something you said wasn't clear, you know, or wrote wasn't clear, and you should be there to clarify it. And sometimes you never know, something pops up in between the reply brief. So my general preparation is, if you ask for argument, then a couple of weeks before, shepherdize everything to see if there's any new authority. And then, so, you know, some districts, they're a lot tougher on this now. They don't want any new authority. They don't care if it's a new case. They don't want it. And you can bring it along with you and talk about it. But usually, depending on the district, then if something new came up or if some review was granted in some case, you'd want to submit an additional authority, and in sufficient time for the other side to read it, not the night before, and sufficient time for the court to look at it. And then a couple days before the argument, I just go over everything and try and memorize as much as physically possible. But you're just, you know, and you just have a few brief points and see if they just sit there, you know, like this.
Yeah.
or they're asking a couple questions, you got to be able to answer them. But big long talks are a total waste of time.
Yeah. I had an oral argument recently where my opposing counsel started to mention a case, and almost before she could get it out of her mouth, the justice said, "Counsel, I don't recall reading that about that case in your briefs. So how can I consider it?" And I thought, holy smokes! I mean, they really know what cases are in there. There must have been, 75, 100 cases cited in all the different briefs, and they can, you could spot it out that quickly. Have you ever had an oral argument where you came out and you thought, "Gosh, I'm glad I requested oral argument on this one. This one really seems like it may have turned the tide"?
Yeah, a few times. I'll tell you though, I've had an argument a long time ago where I was literally yelled at for half an hour and won.
I got to hear more about that one.
Well, that was one of the earlier parental rights cases I did.
Okay.
The guy found out he wasn't the father, and
But you were yelled at by a justice?
oh yeah, and we were suing the mother, and he was trying to get an adjudication that the kids weren't his kids, and because he wanted to nail the other guy who was the biological father. And it turned out that, they've changed the law since then, that we won. We got an adjudication. He's not the father. And so, but they lived as his kids for a couple of years. They thought he was dad. So we were just trying to nail the other guy. We weren't trying to, have him not know the children anymore. But this was out in Riverside. May even been when it was in San Bernardino before it even got to Riverside. But they were pretty incensed. And, my guy did not wear the white hat. He wasn't in the morally superior position. But the law as I saw it anyway, was on his side. You're much better off going in with somebody in the morally superior position.
Yeah.
But things happen.
And last question on oral arguments. Do you have any tips or insights how to anticipate the court's questions? If you've been living with the case, you wrote the briefs, obviously. How do you get yourself out of the box to think of the questions that the justice might have on their mind?
Well, if you have time and staff and your client has money, then you can moot court it. But in the reality of small to mid-level clients, not small clients, but small budget items and small budget cases, and we rarely have anything over a couple of $1 million, $5-8 million. Those kind of cases, if you want to moot court them, they're fine. But dealing with middle class people and middle class businesses, they don't have the time they don't have the funds for 2 or 3 attorneys to sit around and bat something around. But if you have the time and have the budget, then it's good to moot court it.
Yeah.
And obviously, it's just sort of kind of your due diligence in doing the research. If there's any dissents that are anywhere near your case, you want to be familiar with those dissents, because those dissents might turn out to be majority opinions in somebody else's view.
Yeah. Yeah, my the best I've come up with is if I'm an appellant and I get the respondent's brief, I write down my extemporaneous notes, my first reactions, because I haven't read my appellant's brief in maybe a few months. So maybe I'll read the respondent's brief thinking, hey, that's pretty good argument. And then I'll lay them all to waste in my devastating reply brief. But by the time I'm getting ready for oral argument, maybe I want that hot take. What do I think their best arguments were when I first read their brief?
Right. You should be able to respond to that's correct. What you think their best argument is.
Yeah. All right. Well, let's we're running a little bit long, but we would like to subject you to the gauntlet of our lightning round, where we ask you, Jeff, I'll let you take over and run the lightning round here.
All right. This is the time for our patented, copyrighted segment of the show that answers the most pressing questions that vex appellate nerds around the world. Short responses, one sentence where you can. The most vexing questions that concern appellate nerds are: number one, what is your font preference for briefs? Century Schoolbook, Garmond, or something else?
Century Schoolbook 13. That's what they all
Absolutely. That is the only correct answer. 2 spaces or 1 after a period?
2. I'm old school.
Oh, all right. I'm making note of that.
I think we're split about 60-40 on that one. I think we got 60% say in 1 space. I think we get about 30 or 40% say in 1.
All right. In briefs in the California Court of Appeal, your headings, your argument headings, not table of contents and statement of jurisdiction, but your major argument headings, all caps, initial caps, sentence case, or something else?
I don't like all caps. Not even for the main heading. I think it's yelling. I don't like it.
Okay. All right. So you're not terribly old school. That's very progressive thinking. All right. And on a similar note, left justify or full justify?
Just left.
All right. And final question of lightning round. After major headings in a brief, when you're going to a new section, do you start the next section on a new page, or do you continue immediately below?
My sort of rule of thumb, if it's in the bottom third, I go to a new page.
Oh, okay. All right. Nicely done. Very concise. I think that you get the award for the most concise answers to a lightning round ever. So thank you for that. Back to you, Tim.
All right. Well, here's my one addendum. I want to know the answer to this question. When you refer to the Superior Court, is it uppercase Superior Court or lowercase, or do you just say trial court?
No, it's low. It's supposed to be lowercase.
Lowercase Superior Court.
Lowercase S, lowercase C, and same with its trial. Yeah.
Yeah, that's
Superior Orange County Superior Court. Superior Court of Orange County. It's S. But if you're just saying the trial judge, the Superior Court, or the trial court, that's all lowercase.
That's how it's defined in the rules of court. I've noticed as lowercase. Okay. All right. Well, John, thanks for being here. That's going to wrap up this episode. Again, we want to thank Casetext for sponsoring the podcast. Each week, we include links to any cases that we might discuss, and we use Casetext for those links. And listeners of the podcast can find a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
If you have suggestions for future episodes or guests, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
Thanks. See you next time.
Thanks for having me.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.